E, F, and then I broke up F. See how there's two sentences in F?
Yeah.
I broke it up. So I had one, my first damages was E. My second was the first half of F. My next one was the second half of F. Then I had G without the amount because I struggled with what you said. But I don't think you're wrong. Like if you included that, I don't know that I don't think courts are going to be like, oh, that runs afoul of the. I didn't view that as stating the amount of general damages. I think that's just the amount of medical bills.
Yeah.
Which your general damages may go well beyond those. So, but I didn't include it because I saw that and kind of got worried. But I'd probably want to. I'm not a plaintiff's lawyer, so I'd want to kind of think about that a little bit more. This all sounds flippant. I don't mean to be. If I'm sounding flippant, I mean, my wife says I always sound flippant. She's like, I'm like, oh, I see nothing got done. She's like, well, thank you. She's like, yeah. So anyway, I don't mean to ever sound that way. You guys did great. Like this, it's fun. I'm having fun. Yeah.
What was I gonna say? Oh, never mind.
I
forgot what I was gonna say. I don't
You're
know.
doing good. You're doing good.
Thanks.
Where are we? I feel like I'm kind of all over the place. I'm throwing coffee on the floor and being flippant. That's how I did it. That's how I pled the damages. I even included an age too. She's unable to carry on her cleaning business and then has lost profits in the business benefits that she otherwise would have received. I mean, they may dispute that, but if you have a good faith basis to believe that, I think you would want to include that. And then what else? What's after that? I is not really, that's something that you would have wanted to allege up here, right? So it goes to show you that the fact pattern isn't always kind of just it doesn't lay itself out the exact same way that the complaint does. What's after your last substantive allegation, which for me it was like 20? What's down here? I mean, what's here?
I did a request.
I just said that the plaintiff now demands a judgment from this court and for damages against the defendant, listening.
Yes, yeah, I said something like, therefore the plaintiff asks the court to award damages and costs to the plaintiff against defendant Philip Grantham and to award plaintiff any other appropriate relief. But yeah, I mean, that's where you wouldn't want to say, and we're asking for $327,000. These pro se litigants, it's amazing. I mean, it's always a specific amount, and I'm like, how did they come up? They're like $2.5 million, $2,500,000. Every time I open one of these, I think, yes, you got it. Like, I mean, or it's like some wild $3,472,627. I'm like, which calculator did they use? So yeah, there's always a number. Anyway. Yeah, some general statement that the plaintiff is asking the court to award damages and usually costs and any other appropriate relief. Yeah.
This is like a nitpicky question probably, but do you capitalize court when you're talking to
I don't.
Okay,
I would stay consistent with what you do. I don't capitalize court, but then some of the judges that I work for want it. Like, this matter is before the court. Court is capitalized. Other judges don't want it. That's another thing when you work for, 7 different judges. Some want, the record referred to as R.1. Some want it DE1. Some want it D period E period number period 1. Brackets, no bracket. And I'm like, well, I'm just grateful to have the job. I'm like, let me be flippant. And they'll be like, you work for me. So I have no problem being like the worker bee. So yeah, don't be flippant with your supervisor. I think that is stylistic. I think the key there is consistency. I think the right answer, if you kind of blue booked it, I feel like no. I mean, I don't think the Supreme Court, yeah, the court, if you're referring to the Supreme Court, I might capitalize it. I don't know, the United States Court of Appeals for the Sixth Circuit said this. You would want to capitalize United States Court Appeals Sixth Circuit, and then if you said that court also held, I wouldn't capitalize court. I don't know why you would, but some judges would, so there's no right answer to that. But that's a fine question. That's a good question. Yeah.
We also include a demand for trial or jury.
Yeah, that's also a kind of a local rule thing. On some of the stuff I see in our court, we have some that's actually included in the caption, which is a unique thing. I wouldn't expect you to do that. Some courts will want you to put it at the end, whether you're asking for that. In some courts do you consent to having a magistrate judge resolve it. Yeah, I mean, then you can. You don't have to worry about that for our purposes. But that's those kind of technical things, not so much the court one, but this trial by jury is something that you would want to kind of closely look at the local rules. There's all sorts of there's all sorts of local rules. You'd really want to become familiar with what your local rules require, both with respect to drafting a complaint, as well as an answer, and as well as a motion that you file in court, whether it's a motion to dismiss, a motion for summary judgment, a discovery-related motion, all of that you'd want to think about the local rules. It's still not over. You'd want to have your signature block, right, which you almost all had. And then you'd want to follow the local rules there. If you need your bar number, not like, what was that one that we had that was like,
from
Adam Colchester, the attorney. Oh, okay. Not the barber or whatever. You'd want to kind of include some of the contact information that is also in accordance with the local rules. Was this easy? I felt like most of you all did really well with it. There was a couple, my big picture reactions were that I thought some people included a little bit too much in their factual allegations, meaning like one allegation had a lot. I also felt like I saw some legal conclusion type language that you wouldn't want to include unless it's for the sole purpose of serving as like a transition sentence. And beyond that, though, I felt like everybody included allegations which, if true, would establish a cause of action. So, I mean, on the whole, they were really good. I mean, totally for good faith, yeah.
So I've never worked in like a civil law firm.
Well, why not? I mean, you're only a law student.
Well, some, most
I know. No, I'm just again.
Maybe this is a dumb question.
No, it's not. He's gonna be like on the review, assholes. No, I was just.
So I'm just wondering, when do you actually talk about specific damages? I mean, not here, of course, but
like when would you plead them?
Yeah.
We do a trial memo, like closer to trial, and that's when you lay out like medical bills, punitive damages, lost time, future damages. I mean, you have to lay it all out for the court so they can properly instruct the jury.
Yeah, that's what I was going to say, which is a lot of it ends up going to the idea is it goes to jury instructions. The reason why it's not really kind of something that's pled in a specific way on the front end is because you have to engage in discovery. I mean, think about the steps in civil litigation. A complaint is what initiates the civil action. And then you're going to get a responsive pleading, either an answer, which is what we're about to talk about after our few-minute break, or a dispositive motion, like a motion to dismiss. But then once you get past that stage, you're into the world of discovery. And then you're, taking depositions, you're getting medical experts, and it's only after that kind of comes to a close, interrogatories, all of that, that you really start to narrow in on what are the damages, what actual relief are we seeking here, and then hopefully you get settlement, which is the reality in most cases. And then what did these plaintiffs' attorneys then did they get a big check? And now 1/3 of a ton of money is a ton of money. That's why I work for the government. I wouldn't know. Anyway.
I was just going to say that we do it where it's after we usually take a couple depositions and we'll send a demand. Mm-hmm. And we'll say we request this much money.
To the other side.
Yeah.
See, that's not something that the court sees.
Yeah, we do that. We do that.
Basically.
Yeah, we did that pre-litigation. Like that's what I do at work is I write demand letters that we send to the insurance companies that say, here's all these medical bills.
Yeah.
Here's all their time off work. Pay them this much money. And then we do negotiations. If they refuse to settle, then that's a lawsuit.
There's all this that happens. See, I'm all for working for the court. None of this is what we see in court, although we know it goes on. What that's also though relevant to that I think does get into litigation is sometimes you get releases, right? Because if you get a demand letter, they're going to want to attach to that like a release of liability. You get them where they have released liability and they nevertheless go ahead and file lawsuits. And then the question is the release an affirmative defense? And a lot of times it is. Oh, well, here's my lawsuit. Oh, well, here's my answer, which asserts the affirmative defense for release because they released us of liability. And they signed and cashed our check. They had no problem cashing our $60,000 check at Chase Bank. And now they're back for more. But they released us of liability, so that can go to the affirmative defense. But yeah, there's a lot of pre-litigation demand letters, cease and desist. I'm glad I don't have to deal with any of that. That's why I also don't make the big bucks, though. Anyway, all right, let's take a break for just a few minutes, and then I think we can kind of blow through this reading material pretty quickly on answers and talk about that before you end up doing your drafting exercise. So let's take, it's 8:12, let's take 5 minutes. We'll come back at 8:17.
Did you go hard on this?
Yeah, if you don't mind. Yeah, thanks so much.
Yeah, thank you.
Cool.
Yeah, that's what I was thinking.
Yeah, if you guys have a hard copy that you haven't turned in, you might do that.
But I always thought that there was an error on the look at it later.
I should turn this
Everybody certain notes, but I was like,
I'm trying to be funny. Well, it's like no one ants or something.
I'm kind of dissatisfied with mine after going.
Oh, well, don't be.
Should we redo them as well?
Well, no, the point of it, you may be. I mean, I don't mean to like be hide the ball, but what we're going to do is, once we get through the entire course, about 3 weeks before, I will sit down, comb through all of the assignments we've done, and then I will select 5 of them that we'll have to do for you. Well, yeah, no, what it ends up being, I have to look at the syllabus.
I use that for like everything now.
Will they do like specific to the person or is it general?
Specific.
No, it's for the whole class. So I will assign between 2 and, okay, wait. First I'll put in the class the 5 specific drafting exercises that were already completed, and the students will have to go back and thoroughly review and edit their work product, taking advantage of what they've learned. So we're going to do more than 5.
Yeah.
So the question is like, which 5 do I choose? And the reason I do that is because I want you to edit.
Right.
I mean, like in class, based on what we talked about, and based on the reading material, and then go back, edit those, and then
Right.
because if I do select it, then you've already got a head start.
Yeah, I
on
see
it.
what you want.
Yeah,
Not much
and that's
good.
kind of thought of as like the interactive part of the class. Like if you're editing as we go, if you're paying attention in class, if you're taking notes, I
I'm
would
just
edit.
realizing that, like, in mine, I'm really worried about being concise.
Well, yeah, that's fair. I mean, that's something that you want to kind of think about.
Because I
going
tend
along.
to not be that way.
Yeah, no, I'm also that way.
Way too wordy, and so in this
Yeah.
exercise, I think I've like short-sold it a little bit.
Yeah.
So when we've gone through this,
Yeah,
I'm like,
no.
I'm like, I left
All it is for this stage is like you turned it in, you had a good faith basis, you're going to get your points.
Okay.
At the final period, it's like,
Got it.
okay, this is one of them, maybe or maybe not. But if this is one of them that we choose, then you'll have to go back and make it more of a final draft form that incorporates the principles we talked about in class.
We don't have a.
And then you'll have extras. That's 5 of them. 5 of the portfolio includes 5 drafting exercises you've already done that you have to turn in the final drafting form. There'll be like 10 we'll do a third.
Right.
5 you'll have to turn in, and then 2 to 4 new things that you haven't seen before. But it'll be like a new complaint, or a new motion, or a new judicial opinion, or a new, and then you'll have to add that. So the 5 plus the 2 to 4, and then you'll turn them in.
Yeah. We don't have
Tyler?
assignments this week, and so
Well, you will for, the following
We got
week. But
2
yeah.
classes together now.
Exactly, yeah, that's fair. Cool.
Anybody call you KB?
Does that make sense?
Yeah.
Okay.
usually something like that.
Oh, okay.
Oh, thanks so much. Cool.
What about 100% after that? Right, future dividend.
Which one? Oh, yeah. Man, well, I thought 46 pages was going to be longer than it was, but it wasn't bad.
I tried to bring it down to like 6.
I did like 5, yeah. He probably likes more. I don't know if I even did it right, though. Yeah. I'm like, this is what I like that we did. I didn't really know how to tie in the law, but I just said land use nexus a lot.
Yeah, me too.
Have you all started registering for next semester? Are you, who's not Who will be here next year? So a lot of you will have a third year next year.
No.
Who will be
They
here?
all raise their hands. There's none of them are.
Wait,
Only-
Who will be?
Us three and
A
Michael.
couple, yeah.
Yeah.
I think I still am talking to the associate dean. I may end up teaching criminal procedure, like the second
Wow.
half of the judicial process. I was talking to the associate dean about that. So, but that would be in the spring. Just totally different. I guess there's like the legal drafting person is coming back,
She is.
which is great.
I saw her.
Oh, and she'll
Good,
be,
yeah.
she'll be here.
So I may do that. So if you are interested, but that's not until the spring. So a lot of you are graduating. Do you all know what you're going to do? No. So you're going to walk though in like a couple months. That's exciting.
I'm really crying.
That's great.
Hopefully pass it along.
It gets real
I'll
then.
be
Yeah, well.
in the next year.
All right, let's get started. Okay, let's get through this. I think we can move through it pretty quickly so you can get out a few minutes early. So chapter 3, this was the reading material on answers. So this is kind of in advance of the drafting exercise. Just to kind of go through some of this, of course, the purpose of the answer is respond to the allegations in the plaintiff's complaint, right? You have the initial pleading, which is the plaintiff's complaint. You want to respond to their allegations and then also potentially raise any affirmative defenses that are available to you. That'll be the kind of two parts of an answer that you have to draft. The time for responding to an answer, it kind of varies. I mean, that's all dependent on the rules that are applicable in your jurisdiction. Federal court, if you're suing a defendant, it's typically 21 days within the service of the complaint and the issuance of the summons. For a federal defendant, like a federal prison official or the United States, it's 60 days. But that's not something you have to worry about too much. Failure of the defendant to respond, something we don't really have to concern ourselves with too much, but you might remember from civil procedure, which I love, which is sad, but there's kind of two steps to it. You first have an entry of default from the clerk's office, and then the actual default judgment. Federal courts kind of are pretty broad on setting aside default judgments, but that's kind of the two-step process for the entry of a default and then the default judgment. Roman numeral 4 here in the reading material is pretty critical. I mean, it's what you want to think about, right? Which is you're admitting an allegation, you're denying an allegation, or you're stating that you lack sufficient knowledge to form a belief concerning the truth or allegation, or you might have a combination. Here's what I always, and then just real quick, it says if the defendant admits the allegation, the matter is treated as established. If the defendant responds to an allegation with a denial or with a statement that the defendant lacks knowledge, the matter remains in dispute. And then, of course, there's this cautionary note, which I pointed out, which is an attorney should use the response that the defendant lacks sufficient knowledge only when the defendant truly lacks sufficient knowledge. A party must comply with the requirement of honesty in pleading. What I always tell students is if the factual allegation put forth by the defendant is inextricably intertwined with a legal conclusion that you as a defendant dispute, then I think you can deny the allegation, right? I mean, if they say because of the defendant's negligence, the plaintiff was injured, and you believe the defendant wasn't negligent, then you can just deny that. You don't have to be cute with it. I mean, I think students oftentimes think you have to do more in an answer than you have to do. The answer is going to be short. It's going to be like, 1, defendant admits the allegation contained in paragraph 1. 2, defendant denies the allegation in paragraph 2. 3, defendant denies the allegation in paragraph 3. 4, defendant denies the allegation in paragraph 4. 5, defendant admits the allegation, and then new section affirmative defense. It's not, there's no like narrative coming back. The answer isn't like, sit down, I'll tell you what happened. That's not what it is, right? I mean, as much as you might want it to be, it's not like, hold up, this is not true and here's why. No, it's either admit, deny, or lack sufficient knowledge, right? Articulating the 3 basic responses, this is B. B1. It says, below are examples of how one might sufficiently frame an admission and a denial, and here it is. And these I think you would want to, you look at this when you're drafting your answer. defendant admits each allegation in paragraph 3 of the complaint. Or if you really just have one allegation, which is what I think you should have, one allegation per paragraph, right? Meaning each of these are, I don't really call them paragraphs, I call them allegations because I tend to do one allegation per numbered allegation, but they're calling them paragraphs here. That's what you want to say is defendant admits the allegation in paragraph 1. Or defendant denies the allegation in paragraph 1 or paragraph 4, whatever it is. That's all it is. Now, the hard part is really kind of behind the scenes, which the court isn't going to see, and I'm not going to see, in a sense, which is like, it's going to be you figuring out whether you admit or deny, and maybe including kind of or thinking to yourself as to why you admit or deny that, and being prepared in class to talk about, like, hey, I think that I would have admitted this because of this, or I would have denied this because of this, or I would have stated I lack sufficient knowledge because of this. Like, it says defendant lacks sufficient knowledge to form a belief concerning the truth of each allegation set forth in paragraph 7. I've seen this too. It says, look in the next box on page 46, PDF page 46, it says defendant admits each allegation in paragraph 1 of the complaint for jurisdictional purposes only. That's a very common way of responding to the subject matter jurisdiction allegation, saying for jurisdictional purposes only, the defendant admits this allegation. Or the defendant admits this allegation for purposes of jurisdiction only. Why say it that way? Because you're not admitting that the plaintiff actually suffered that much in damages. You're just saying, like, I admit that the amount in controversy here is over this, but I'm not admitting that I was liable in any way for that amount. You're just saying, for jurisdictional purposes only, this is established. While many attorneys prefer the terse admit, deny, and insufficient knowledge to form a belief as to truth, failing to specify in your responses the paragraph to which you are responding could lead to trouble if you accidentally skip a paragraph in a pleading containing numerous paragraphs. I think you want to include what your allegation, or which allegation you are admitting or denying. So you want to say something like defendant admits the allegation in paragraph 1 for jurisdictional purposes only. The defendant admits the allegation in paragraph 2. And your numbers should line up with their numbers. Then it's really easy. Because you've got a number 1, they've got a number 1. You've got a number 2, they've got a number 2. And to the extent their number 3 is a cluster, some of which you deny because it's all mixed in. Oh, the defendant negligently left this all over the floor and blah, blah, blah. You'll see that. I mean, you'll get these where the factual allegations are poorly drafted. Poorly drafted complaints exist all the time. I'm sure people who have done work in, only those of you who have actually worked in law firms. Totally teasing. You've seen them. Poorly drafted complaints. It might even be in your own firm's files. Those exist. And so if you've got if you're representing a defendant, that can be beneficial to you because all you're thinking is, we deny it. You know, you don't have to. If they include, I don't think, and so I guess I'm teaching the class, so this is the rule. If this is the plaintiff's factual allegation, and it's 6 sentences long, and it includes some things you totally disagree with, some things you're kind of prepared to admit, some things you don't, I think you can say that you admit, well, here's what I would do with that. If you've got a cluster of an allegation that you're trying to respond to, the easiest way to deal with that as a defendant is to say something like, defendant denies the allegations in paragraph 3 of the complaint, comma, except the defendant admits the following fact, colon, and then you say what you're willing to admit. Because the problem is, if you just say, oh, well, it's a cluster, defendant denies the allegations in paragraph 3. The problem is, there may be something buried in there that you're like, well, but I kind of admit, like, that. I don't really admit that. Oh, well, that's kind of true. I think students are like, oh, what do I do? It's all, take the power back. Take the power back. And what do I mean by that? say, like, basically what you're saying is, I don't know what kind of cluster that is, but here's what I will admit to. So you could say, defendant denies the allegations in paragraph 3, comma, except the defendant admits the following fact. The defendant owns a jewelry store operated at 212 Tennant Street in Old Town, Kentucky, right? Because maybe that's buried in some other terribly pled allegation. But you don't want to totally discount that. Now, if it's a one sentence where a legal conclusion like negligence is inextricably intertwined with another allegation, then I think you're in safe ground to just deny that. Because you're like, but for the defendant's negligence, let's say you're in the causation world, but for the defendant's negligence, but for the defendant's gross and horrific negligence, comma, poor Portia Pond would not have been harmed. I'm denying that. I mean, that's insane. First of all, that's ridiculous. But second of all, maybe you admit that. Do you have to say, well, she was harmed, so do I admit that, but that I wasn't responsible? No, if it's a short thing where the legal conclusion is mixed in a kind of tight way with a fact, and you dispute the legal conclusion, you can deny it. If it's a narrative, a set of allegations in one paragraph, 5, 6 sentences, and you feel like some of those sentences you may admit, but some of them you deny, but it's all written in one, the best way to do it is to say, the defendant denies the allegations contained in paragraph 3, comma, except the defendant admits the following fact. And then you can put it in your own language. And part of that, I'm talking a lot, what is another reason why you would want to do it that way? Why do it that way? Why not just say, well, we deny it, or defendant lacks sufficient knowledge? Yeah.
Well, I think it gives you a chance to reframe the narrative and how you want to say okay, defendant admits that we had control of this room, but defendant otherwise denies allegations in this paragraph. So you phrase it how to make you yourself look better.
Well, yeah, I think it kind of casts your own client in a positive light too. I think that's right. I think related to that though is this idea, and this kind of goes to this admitting allegations in part, and it ties into this third number, which is avoiding an evasive response. Like defendant neither admits nor denies it, but puts plaintiff to reprove what? That kind of well, I don't know, it's not my burden. You want to avoid not responding to an allegation, meaning you want to respond to the allegations because if you don't, the court might deem it as evasive, but also the court might deem it as admitted. So the way you avoid maybe inadvertently admitting something is to say, I deny the allegations in this paragraph, but I admit the following fact. So nobody can say, oh, you are being evasive. 2, you are not running the risk of inadvertently not responding to an allegation in this mess, and therefore the court's saying, oh, you admitted it because you didn't respond to it. And I think it does what Kirby's suggesting, which is puts your client in the best possible light. It allows you to take the ball back and say, hey, this is how I'm going to phrase it. I admit that there was leaky fluid. The defendant denies all of the allegations in paragraph number 3, except the defendant admits the following fact. The plaintiff slipped and fell on jewelry cleaning solution. But maybe you admit that, but maybe you think she dumped it. I mean, we don't know all the facts. Maybe she's like, there's jewelry, well, that's a different set of facts than she strolls in and there's a bucket of leaky fluid on the floor and she slips and falls on it. So, but maybe they're there was fluid on the floor. And so you want to admit that limited fact. Because if you don't say anything about that in that huge paragraph, they might be like, you admitted these things. But if you say, you know what, I don't know what she's alleging, so here's how I'm going to say it. Defendant denies the factual allegations in paragraph 3, except the defendant admits the following fact, and then you can cast it in the light that's most beneficial to your client. Avoid an evasive response, and then not run the risk of inadvertently admitting something. Does that make sense? So here's what you need to be. Well, let's see. Responding to conclusory allegations. I think that's pretty self-explanatory. And then let's hold off on affirmative defenses. So the first part of your answer is going to be one, and you'll see a template answer in the case file. It'll probably not be great, but you'll see something that you can kind of look at. There's really kind of two critical parts of the answer, which is the first part is you responding in a numbered way to each of the allegations put forth by the plaintiff. Admit, deny, lack sufficient knowledge. The key takeaway, I think, is if a sentence has an ultimate fact mixed up with a legal conclusion you disagree with, I think you're fine to just deny that allegation. On the other hand, if you've got a narrative allegation that has maybe 4 or 5 allegations in one paragraph, and you're mixed up, you're not sure, don't stress, just deny it, except you admit something in a very kind of discreet way, only what you're willing to admit. Okay? Does that make sense? That's the first part. The second part is then you want to plead affirmative defenses. So on this page 50, it says, an affirmative defense consists of new facts, facts not addressed in the plaintiff's pleading that the defendant may raise in the answer. So it's kind of like an exception to the whole sit down. You don't say sit down, let me tell you the story. It's a little bit like you do. You do introduce new facts because in a way, it's not a counterclaim. I mean, you could have a counterclaim in lawsuits, right? I mean, you can have that all the time, right? Like, you're suing me, oh, wait, I'm going to sue you. We're not going to do that in here. But it functions in a way almost like a new complaint. Like, hey, here's what's going on here. And by the way, let me add this, because I bear the burden of proving up this defense, which is, on this date, we sent you a letter releasing us of liability. On this date, you signed the letter and said, thanks, so glad we got this behind us. Love, Portia. On this date, you cashed the check and endorsed it. Glad it's all over. You know, on this day, you sent us a thank you note for your generous settlement. But it is pleading new facts that don't, well, let me say this. Let me ask it this way. How does an affirmative defense relate to the elements of a cause of action? Do you guys know? Yeah.
I mean, you could, in theory, you could make everything in a cause of action, like 1, 2, whatever, and say, yeah, every single one of these things happened, but I have an affirmative defense, meaning, like, for instance, you're outside of the statute of limitations, so all of these things you said are true, but it doesn't matter because you can't sue me.
Yeah, exactly, and the reading material makes that clear. It says a federal court in New Mexico recently described an affirmative defense as a defense that does not negate the elements of the plaintiff's claim, right? I mean, it doesn't, an affirmative defense exists independently of the allegations. Now, it could be you admit all the allegations, which it won't be in your case, but it could be you admit all the allegations, but you're still barred from relief because of the statute of limitations. Or it could be, I'm going to deny these allegations, but even if they were true, you're still barred from relief. So it's kind of like, it could be I don't want to talk about this, I want to focus on the affirmative defense, or it could be both. I don't think you have a case, deny, 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 but even if you did, my second argument is affirmative defense, right? So it does not negate the elements of the plaintiff's claim, but instead precludes liability even if all of the elements of the plaintiff's claim are proven. It avoids liability, either wholly or partly. The ones you're going to want to think of are we'll talk about release. Look at the facts and what law is brought to bear. Kind of like you're going to look at the law on premises liability. And in an answer situation, you're going to be given some law on things like releases or things like contributory negligence. Those are some of the ones you're going to want to think of. There are all sorts of affirmative defenses: support and satisfaction, assumption of the risk, duress, estoppel. I mean, you've studied these statute of limitations, statute of frauds. That might bring back your nightmares from Contracts 1. So don't, I still wake up in a sweat sometimes. And then say 10 years later, I'm like, don't call on me! I shouldn't have told you that. It gets better for those of you that, anyway. Now I'm into my own mental health issues. Okay, so the point is, for our purposes, affirmative defenses, I will give you instructions on kind of what you might want to think about pleading as far as affirmative defenses go. Let's go over to pleading inconsistently hypothetically. That's not something you have to worry about kind of too much. The point here is that in complaints and answers, you can have kind of alternative ways of pleading, right? Like, this is true, but if this is not true, then there might be another option. That kind of is somewhat consistent with an affirmative defense. But you would want to list, formatting the affirmative defenses is kind of important. You would want a heading that makes it clear that this is the first affirmative defense I'm raising, or this is the only affirmative defense I'm raising, or this is the first and the second affirmative defense. So you would want to kind of make it clear. That's where a heading, I think, is almost a necessary thing. This is how I want to plead my affirmative defense. Responding to the answer via reply, that's not something you have to worry about. We're not going to deal with replies. It's just noting that some courts actually want a reply pleading. That can sometimes exist. For our purposes, really, we're not going to deal with that. I often think about replies when you're briefing motions, substantive motions that are filed in court, a motion, a response, and a reply. Most local rules contemplate that. It's not something we're going to worry about for our class. The rest of this material, similarly, there's all sorts of issues that can come up, like special matters, capacity, minority, fraud or mistake, special affirmative defenses. We're not going to worry about those too much, but there's a lot of things like fraud is a special thing you might have to plead. It's not something we're going to deal with in our class, but it's something you should kind of be aware of that exists out there. So here's our plan with 2 minutes to go. There's no class next week, remember. By this Wednesday at 5, I will post a new case file. Where will I post it? Right under here. If you go to drafting exercises, by Wednesday at 5, under this folder, it's not coming up. Well, there's the folder, you know what I'm talking about. Where I will post the new, here it is, new drafting exercise. I'll post it by Wednesday. And then it will be due, not this Saturday, but the following Saturday at 5. Send it to me electronically, and then turn to the reading assignment, which is on motions. Any questions? I don't think it'll be real bad. It'll be a shitty complaint that you will have to respond to, and you'll be admitting some, you'll be denying some, and you'll probably be doing some of this. Deny, accept, the plaintiff admits the following fact, and then you'll plead 1, maybe 2 affirmative defenses. I still want to tweak it a little bit, but I'll have it updated in the next few days. Yeah.
Oh, that's good.
Yeah. All right, guys. Well, I'll see you in 2 weeks.
So
have a good one. Yeah, it'll be the same type of a caption. The title, the answer or answer to premises liability complaint. It doesn't matter. No, I think you could include a commencement. You could say defendant responds to the plaintiff's complaint by defendant responds to each of the plaintiff's allegations as follows. Something like that. But the reason why I didn't kind of go over all that is there's going to be a sample answer in there. So you can kind of pattern it after that. Now that won't be perfect itself, but it'll at least kind of like you had a draft complaint in your case file. Remember that? That was terrible. But it at least got you something to like go off of. So that can function as a model for like how you style it. And then you can just respond accordingly. It'll be really easy because it'll just be like, number 1, plaintiff admits. Number 2, plaintiff denies. Number 3, plaintiff denies, etc. And it's the following fact. It'll be much shorter than this assignment was.
And then this is...
That'll be a separate affirmative defense, and then it'll either be 1 or 2. Yeah, I'm not sure. But if it's 2, it'll be like first affirmative defense, release. Okay. And then you'll plead allegations that'll look more like this, but what those allegations will be are allegations that go to each of the elements of the affirmative defense. So like I'm just making this up, this is just right. But if a release is proved by a signed document that releases all liability, if that's the law on releases, you would then want to plead allegations. On this date, she signed on this date, or that document said it quote releases them of all liability.
Okay.
Something as simple as that.
And are those?
And similarly, if contributory negligence is one, there'll be law that's given to you on contributory negligence. It's like, one, was she aware of the hazardous condition, and two, did she knowingly,
Okay.
you know, whatever, and then you'll have to plead, kind of like you would a complaint. All of this is good faith.
Okay.
So we'll talk about it in class.
Oh, so does each one have a new number? So affirmative defense one, new numbers?
I think you could, I would do it sequentially, I think.
So stay with.
I would stay with it.
Okay.
But I'd have to think, I don't know though. I don't know that that matters because we're not dealing with a responsive pleading coming back. The key for our purposes will be having in the answer, if there's 5 allegations you're responding to, you have 5 different numbers that match their allegations. And then if you have an affirmative defense, I think I would do 6, 7, 8. Or you could just do 1, 2, 3. I don't think that matters. Because you're not, as long as these match that, I guess I would be inclined to continue the numbering, but I'm not worried about it.
Yes, sir. Thank you. What was I about to say?
Does that make sense?
Yeah. No.
Okay.
Can you give me some life advice or
Yeah.
motivation? I have an interview tomorrow with